money, banking, and trust by moving titles in commerce. Featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or short recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
I'd like to welcome everybody to this Monday, May 31st edition of Money, Banking, and Trust by Moving Titles in Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. This is the Monday night Trust Ambassador call. This is the Q&A for that. But the topic for tonight is really a review of last Saturday, which was the remedy at law. And tonight's topic is a review of that. And the question was really, how do we get into a court of equity to get a remedy? How do we get into a court of remedy, or a court of equity to get a remedy? So to get into the queue and ask a question, press star 6 and star 1. But this is from Book 30A, Corpus Juris Secundum, starting in section 17 again. In general, the adequacy of a remedy at law as a line of demarcation between the courts of law and of equity is strictly preserved. It says the touchstone for equity is the lack of an adequate remedy, legal remedy, excuse me. Touchstone for equity is a lack of an adequate remedy at law, as discussed in section 18 infra. The scope of equity is inversely related to the scope of the available remedies at law. And further, the line between law and equity is not only sharp and distinct, but it is variable and changing. Where the legislature has created a clear remedy for a specifically identified evil, the court of equity will enforce that remedy. A court of equity cannot exercise jurisdiction over a matter which has by statute been expressly entrusted to another tribunal of adequate power to deal with it. And remember, power is not force. Power is the ability to act or not act. And we all have power, because really power is discernment, to be able to act or not act. So that's power. And we're confusing power with force. And we want to enforce something. But power and force are two different things. Section 18, lack of remedy at law as ground and limit of jurisdiction. As a general rule, the adequacy of a remedy at law, that's the ground, is both the foundation of and conversely a limitation on equity jurisdiction. Unless the legal remedy is made exclusive by statute, generally, equity may be stated to have jurisdiction in cases of rights recognized. Rights recognized. So they got to recognize your rights. And protected by the municipal jurisprudence where adequate and complete legal remedies cannot be had. In other words, the touchstone for equity is the lack of an adequate legal remedy. The touchstone for equity is the lack of an adequate remedy. So it must be alleged facts into evidence demonstrating a lack of adequate remedy. And we want to go to the action to enforce below, where it's talking about an action to enforce pre-annexation agreement, where was the village's action seeking to enforce provisions of pre-annexation agreement was improperly dismissed under theory that the amended complaint was deficient because it did not allege facts demonstrating that the village had an adequate remedy at law, had no adequate remedy at law, So the touchstone for equity is the lack of an adequate remedy at law. To invoke the powers of court of equity, it has been required that it firmly appears from the face of the pleadings and from the evidence that the plaintiff has no adequate remedy at law. So where a case presents such complications, and what complications are they talking about? Well, that's the no adequate remedy at law. Such obstacles to a disposition at law and such questions peculiar to equity as to make it manifest that a court of law could not so deal with it as to offer a proper adjustment and bring about a complete determination or complete termination of the contention. Equity has jurisdiction. I'd like to welcome everybody to this Monday, May 31st edition of Money Banking and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT. We were in the middle of discussing the remedy at law, which we talked about last Saturday. But tonight's topic is, again, how do we get into a court of equity to get a remedy? And for a quick review, under Section 17, under Book 38, Corpus Juris Secundum, the touchstone for equity is the lack of an adequate remedy, as discussed in Infra Sections 18 through 20. Number 18, the lack of a remedy at law as ground and a limit of jurisdiction. The rule is an inadequacy of a remedy at law is the ground, is both the foundation of and conversely a limitation on equity jurisdiction. So unless the legal remedy is made exclusive by statute, generally equity may be stated to have jurisdiction in cases of rights recognized, and I got to recognize your rights, and protected by municipal jurisprudence where adequate and complete legal remedies cannot be had. In other words, the touchstone for equity is the lack of an adequate legal remedy. The touchstone for equity is the lack of an adequate legal remedy. To invoke the powers of the court of equity has been required that it affirmatively appear from the face of the pleadings, and from the evidence, the facts, that plaintiff has no adequate remedy at law. So where a case presents such complications, and these complications are it's no adequate remedy at law, such obstacles to the disposition at law, and such questions peculiar to equity. Equity is peculiar. It's special circumstances, peculiar circumstances. Continuing on, as to make it manifest that a court of law could not so deal with it as to effect a proper adjustment and bring about complete termination of the contention. Equity has jurisdiction. And conversely, equity will generally not take jurisdiction where there is an adequate, complete, plain, and speedy remedy at law, unless it is shown that there is some feature of the case which is peculiarly, there's that word again, peculiarly within the province of a court of equity, or unless special, there's that word again, special jurisdiction has been conferred by statute, or unless it has been held by some special, there's that word again, special, and substantial ground of equity jurisdiction is alleged and, if necessary, proved. So this general principle has been embodied in some statutes. Its application necessarily depends on the factual circumstances in each case. And in this connection, the phrase, quote, adequate remedy at law, unquote, has been said to be a legal term of art having a settled and well-known meaning in equity jurisprudence as referable to the remedy for damages in a civil court. As the rule is sometimes stated, equitable remedies cannot be pursued until legal remedies have been exhausted. The rule is sometimes stated that equitable remedies cannot be pursued until legal remedies have been exhausted. And ordinarily, a bill in equity cannot be maintained to obtain precisely what plaintiff can secure by an action at law. The theory that the rule that equity will not take jurisdiction where there is an adequate remedy at law is to be taken as indicating the origin of equity jurisdiction and as defining generally its grounds and objects. It is more generally adopted that the theory that the existence of an adequate remedy at law is a constant limitation on the exercise of jurisdiction. Where the latter theory prevails, the courts in adopting it have generally been influenced by statutes in terms restricting equity powers to cases where there is no adequate remedy at law. But in other jurisdictions, such language in general statutes is held to be merely descriptive of and not intended to restrict equity jurisdiction, and is not precluding the broader doctrine. The rule that equity will not grant relief where there is an adequate remedy at law applies only when, on the case stated, there is a legal remedy. The distinction is to be observed between a case cognizable at law, but for which the law has no adequate remedy, and a case that has been adjudicated on its merits only in a court of equity. In the one, the equity court is invoked only for a remedy, and in the other, for the adjudication of rights of the parties on the facts. For the adjudication of the rights of the parties on the facts, where the suit is properly cognizable in equity. The existence of an adequate remedy at law may justify a court of equity in refusing to entertain the matter. And where the matter is legal in nature, the absence of an adequate remedy at law is necessary to confer equitable jurisdiction. If on the facts stated, the case is of a nature cognizable only in a court of equity, plaintiff will not be shut out of court on the suggestion that on other state of facts he might recover which would be equitably satisfactory in another tribunal. So let's back up. Let's talk about the purpose of creating the tribunal. In the footnotes, it says equity jurisdiction is limited by existence of a tribunal created or given additional power for the very purpose of making factual determinations and alleviating hardships of an oppressive statute as applied to facts related by each complaint. Facts related to each complaint. And now equity supplements the law. In the footnotes, 1, it says, its office is to supply defects in the law. Defects in the law. Man, did anybody realize there were defects in the law? Its office is to supply defects in the law where the law is deficient by reason of its universality, to the end that rights may be protected and justice be done between the litigants. So, there is a chance between the parties that justice can't be done in the law form that you're at. And number 2, equity is intended to supply deficiencies in law and is not to be exercised as a substitute for law, but is to be supplement it and to furnish relief in those cases in which speed may be necessary or disorder or irreparable injury may result from necessity of following ordinary course of law. Irreparable injury may result from necessity of following ordinary course of law. And now the character of cause of action. Equity will not take jurisdiction where cause of action is not such that a court can apply appropriate remedies and give appropriate redress. And now purely legal demands. A purely legal demand cannot ordinarily be enforced in equity. And now the collateral view. A rule that equity will redress a wrong and for which there is no adequate legal remedy does not mean that where a tribunal is provided to do a given thing, equity will have jurisdiction collaterally to review its decision if there is no method provided by statute for doing so. Now again, the action to enforce pre-annexation agreement, the village action seeking to enforce provisions of pre-annexation agreement was improperly dismissed under the theory that the amended complaint was deficient because it did not allege facts demonstrating that the village had no adequate remedy at law. And now the basis and the purpose of rule. The rule is found on the principle that legislatures have authority to define the rights of citizens. Legislatures have the authority to define the rights of citizens and prescribe the rules by which such rights are to be determined. I sure question that one. They may have the right, but we need to take that one back. Now, peculiar and extraordinary cases. When peculiar and extraordinary cases arise, customary forms of ordinary law are often not adequate, and fiber of legal thought necessarily must be woven from equitable principles. There's those words, peculiar and extraordinary. Now the effect proviso, the statutory proviso that chancellor shall not hear and determine any cause where sufficient remedy exists at law is both a restriction on chancellor in exercise of general equitable powers of chancery court, an implied grant to legislature of authority to restrict chancellor in exercise of such power by creating sufficient remedy in some other tribunal exclusively. Now, all these have case sites underneath them for those little topics, and some of them are very interesting, but time constraints, they should be checked out and looked into further, because these case sites are explaining these subtopics. Now, next page, 180, the reason for rule. Otherwise, the constitutional right to trial by jury would be infringed. And the next one was applicability of maxim. The maxim that if there is no adequate remedy at law, equity should act. Presupposes remedy which is inadequate and may not be invoked when there is no remedy at law. And now the equitable nature of right. The right to the relief sought need not be first established at law, where such right is in itself of an equitable nature. So that sounds like that if you have an equitable right at law, can't establish your right. It's already been established. And there are a couple case sites to check that out further. So press your *6 button and *1 to get in the queue line for questions and answers. And remember, the topic tonight is, how do we get into a court of equity to get a remedy? And this is a review of last Saturday's Remedy at Law show that we did. Remember, get in the queue, press *6, *1. So. Bill, you're unmuted. Go ahead.
Hello. Good evening, Christian. Bill from New Jersey. How are you?
All right. Okay. Got some bugs going around here.
Okay. The last statement you made about if you have a claim, if you have an equity claim, isn't that like prima facie evidence to say that you have access to the court of equity?
Yes, if it is an equitable nature right, then law can't touch it. It should be cognizable in equity right off the bat without the establishment of the law side saying that you can get in there.
So then, if we're structuring our remedy, our corrections vis-a-vis trust, and then either the beneficiary or the trustees, that there's a breach, the beneficiary indicates there's a breach.
Yes.
Doesn't that qualify automatically for equity?
Yeah, I believe so.
So then maybe that's, as you say, the bingo.
Yeah, because trust is solely in equity, period.
Exactly, right. So then maybe that's, isn't that, we've been trying to seek a way to get in, but it's right in our face in that regard, right?
Yes, that's what I'm trying to point out. I believe it is right in our face. We are equity as trusts. There is no other way. It's not at law. Although we'll probably try and trick you to give you a remedy at law for your trust.
Now, an issue regarding trust with respect to the trustees, if you have co-trustees, can one trustee bring an action against other trustees for failing to correct a breach?
Yeah, because you're trying to claim jump on my trust, and you got no right to be in here. So you trustee over that one is, infringing and breaching this trust.
No, that's not what I mean. You and I are co-trustees.
Okay.
The terms of the trust say that, you have to give me water every day. And you don't do that. And to protect the rights of the beneficiary who needs the water, I'm going to command you, compel you to do that, right? I can bring an action for you to do that.
The beneficiary brings an action to?
No. I am a co-trustee with you.
Okay, you're going to try and force the other trustee to do
the duty.
The duty to the beneficiary.
Yeah.
Yeah, you have a co-duty to do that, yes.
And is that, okay, now, can I do that through an injunction?
Yes, mandatory injunction.
Okay, so then all those activities are in equity because they're trust issues.
Correct.
Right? So then, sounds like we're on solid ground then.
I think so. That's what I'm trying to point out here.
And then also in reading in Bogarts, if you have multiple trustees, you can have a sole beneficiary where the grantor can be grantor, trustee, and beneficiary. Likewise, if you have multiple beneficiaries, you can have a sole trustee where the grantor can be beneficiary and trustee.
Mm-hmm. Right.
So that gives us pretty large, gives us extra leverage.
We just have to learn that we have the right already under trust, and we just have to know how to enforce it. That's my next question. How do we get into a court of equity, okay, by trust, but then how do we get a remedy once we're in equity?
Well, if by definition we're in equity because of the breach, the trustee is now the defendant, we prove there's a trust, and it's in the court. The court then will correct the breach.
Yeah, I realize everybody's kind of like at a disadvantage because they might not have the material that I'm looking at and might not have had a chance to study it. But what jumps out is it says that the touchstone for equity is the lack of an adequate legal remedy. And down below a little farther it says, it has been required that it affirmatively appears from the face of the pleadings and from the evidence that plaintiff has no adequate remedy at law. Now, how could you demonstrate that? Well, what's it really talking about? Well, the face of the pleadings, that's got to be, the main thing that the court's going to be looking at. That's going to be stating blatantly at them and applying to their conscience that there is no adequate remedy at law. And based on the evidence or the facts. But what is that specific evidence and facts, and what is it you're going to put on the face of the pleadings that demonstrates there is no adequate remedy at law? Because this is the complications that it's talking about, and it's the obstacles to the disposition at law and the questions to the particular, to equity, where the court of law could not so deal with it as to effect a proper adjustment and to bring about a complete termination of the contention. Because at law, you can't get a termination under trust. Equity has jurisdiction then. And conversely, equity will generally not take jurisdiction where there is an adequate, complete, plain, and speedy remedy at law unless it has been shown that there is some feature of the case which is peculiarly within the providence of the court of equity. So how are we going to show that on some feature of the case? How are we going to show this peculiarity so that the providence of the court is going to be under equity instead of at law? How do we get into the special jurisdiction? And it goes on. It says, unless special jurisdiction has been conferred by statute or unless there has been held some special and substantial ground of equity, jurisdiction is alleged and, if necessary, proved. So how are we going to come in with this special and substantial grounds? What is the substantial grounds they're talking about here for equity? And that we may have to prove, or if we at least allege it, that the courts are going to take and make it cognizable under a court of equity instead of cognizable under court of law by default. Where are the factual circumstances so we can get an equitable remedy? If anybody else wants to unmute, I'm going to see if we can unmute 4 people in the queue right now and see if they got any comments on this, what we're trying to go over here now. All right, you're all unmuted that are in the queue line right now. There's 4 of you.
Okay, Jacob here.
Jacob? Okay, who else is on?
Chris.
Chris? Okay, who else?
Floyd.
Floyd, good, and Bill?
Yes, I'm on.
Anybody got any comments they want to make one at a time?
Can I go first?
Yeah, go ahead, Chris, if you want.
Okay. Well, it appears that if you could prove that the elements of a trust exists, then by you putting forth the claim that there is either a breach or some kind of a lack of there within that trust, that would automatically put it into equity. Is that correct?
Okay, anybody else want to make a comment?
Well, this is Floyd. What I'm seeing or picking up from this is that if the law or the codes and whatever else are available, that if it doesn't give the remedy to us, which so many times we haven't gotten, then the only way we have to go is equity, because obviously equity will give us that which the codes will not. The thing that comes to my mind is that most of the time that we're in court is to just pay money to the court, and they do whatever they can to bully us into doing whatever it is that they want us to do. And that would be the only way that I can see that equity would be a way to get a fair dealing.
Okay, anybody else want to make a comment?
Well, it seems to me, this is Michael, it seems to me that I'm getting feedback. I'm going to have to get out.
This is Bill.
Yeah, go ahead, Bill. We'll come back to Michael. We'll open him up and he can make a comment then.
I think, right, okay. When Chris was saying that you're asking us how do we get into equity jurisdiction, but if we allege that there's been a breach of a trust, and we have the proof that there is a trust, then that seems to be prima facie to say that it falls within the jurisdiction of equity. Now, are you saying that even though that may be the case, that still we need something more to prove that it's outside remedies at law?
No, I'm not trying to allude to that. I'm just trying to get everybody's comment, what they think so far and what I was talking about so far. But it says affirmatively appear from the face of the pleadings and from the evidence that plaintiff has no adequate remedy at law. And the thing I'm keying in on is on the face of the pleadings and from the evidence.
So
that there is no adequate remedy at law.
So we would just say that. We would say that this is a pleading in equity, that it's a jurisdiction of equity, because law can't handle equity, and this is the breach, and we demonstrate with evidence what the breach is.
Yeah, I would say law can't handle the trust.
Okay.
All right, so let's mute everybody else out and bring Michael back on for his comment.
Can you hear me?
Yes, go ahead.
Yeah, it seems to me that we claim this special trust, and we say that this cannot be heard in law because it's a private trust. So how can it be heard in law when it's a private trust? And it goes back to filing the proper documents where it's in camera and everything else. But it's to try and force the judge, and that's what the bottom line, what we're trying to do here, is force the judge to see that it is a special trust, and this is where possibly bringing in the Declaration of Independence, and let him actually see that, because I recall that anyone that has tried to bring in the Declaration of Independence or the Constitution into the court automatically says that it can't see this. So this has to be done where he actually sees this into the court records in the private side when we write to him in camera and being certified, because normally what they do is they either lock somebody up trying to do this, or they just throw the whole thing out. This is from what my experience is from other people that I've spoken to, and I don't know if we should actually send those documents to him and say, this is the special trust. This cannot be heard in the public. And we have no remedy at law because it's a private trust, and to protect you in your privacy from the public, we must discuss this in private, in chamber.
Has everybody else had a chance to speak? Let's see, is Matt on? All right, have we heard from Jacob yet? Let Jacob speak now. Jacob, you're unmuted. Come on back.
Hello.
Comments?
Can you hear me?
Yes, go ahead.
Okay. I don't know. When I think about it, it appears that the first issue is, who is the person standing there? Are they someone who has rights to be heard? Are they standing there as a homeowner? Are they standing there as the attorney in fact? Is their attorney standing with them? Are they standing as a trustee? So I think the first thing would be, who's standing there, and to make sure that who's standing there has the most, the best disposition. If a person wasn't under their personal jurisdiction, there would be special circumstances to begin with. It seems also that if you're going to bring up the inability for a legal remedy at law, whereas everybody's bringing in, they think they're going to bring in a case that's similar to theirs, that's going to be a precedent, but in fact you could probably bring 1 million cases in where people lost with the exact same circumstances at law already. And the fact that the real, in a mortgage situation, as an example, you would have an alleged lender, and it actually would be a international investor, and they would be sitting under the UN law, international law, under an international promissory note, and you would never be able to have jurisdiction over them in that courtroom. And then, in addition to that, if you know how to present yourself in a manner which you are actually under your own law form, which is not the law form at law, then I think it appears to me that these would all constitute, in a combination, combined together, special circumstances.
Okay, has everybody had a chance to be heard? Yeah, go ahead, unmute everybody, see what. In the queue, yeah.
Christian?
Okay, everyone in the queue is unmuted right now again.
Can you hear me?
Yes, go ahead, Chris.
Well, I know that it's kind of like a wide spectrum, but when you look at statutes and you look at that as being without a remedy or in debtor creditor, if you are claiming a trust, generally speaking, if it's a private trust, from what I have, is that it's exempt from statutory considerations, unless there is an area, at least from my understanding, if there's an area that's vague, then that's where statutory trust law can step into it. I think that the elements are important to establish trust, such as like from what Jacob was saying is that if you've got a mortgage company that's walking in there and they've got a trustee, I mean, well, that's part of the elements of being a trust. Therefore, the intent of the grantor settlor, no matter what it was to have honesty and good faith. And because there is such a large volume of dishonor and ripping and raping financial wealth and prostituting the person's identification, shows that there is a major breach of trust going on, regardless of any of the statutory laws. It's evident if you take a person's information and you prostitute it or fractionalize it or whatever you want to call it, and without their permission or consent, that certainly would be prima facie that was not their intent as grantor or settlor. So therefore, there is your breach right there. There's your elements of a breach. I hope that helps.
Anybody else want to make a comment? Those that are unmuted? Those are in the queue line. You're unmuted. No other comments on it? Well, I think of everybody we listened to so far, I think, Chris, you said it plainly when you first came on there, you know, the face of the pleadings and the evidence. And I think Michael was pretty good at how he explained the evidence, which he was really talking about, bringing that evidence, he was talking about in chambers. Because I think that's what they're talking about there. When their evidence is brought in to at a hearing, and that hearing is an in-chambers hearing. So it looks like today everybody is not really getting a remedy because they're really not putting evidence at an evidentiary hearing. And there is no evidence in any case other than it just being filed plainly into the case generally under a general deposit. It's not being specifically placed into evidence, especially in an in-chamber hearing, because that's the only place where evidence is heard. That's where the facts are placed. So if we put something on the face of the pleading, and that would be, say, a cause of action for a trust, and trust solely operates in jurisdiction of equity and equity alone, it doesn't operate on our statutory side, public side, especially if you don't have a statutory trust, then its remedy is solely in equity because it can't get an adequate remedy at law. And by default, a private trust has to be heard only in equity. But then there has to be the evidence presented into the in-chambers hearing to substantiate the claim. So the face of the pleadings would be the NOI, and the evidence in chambers would be the SOI that would set up the peculiar to equity situation or the special or substantial grounds for equity to take jurisdiction. Because we're talking about the allegation or it is alleged first, which would be NOI, and if necessary proved, which would be the SOIs and an evidence in chambers. And that would be the factual circumstances. And then you've got the fact that you're pointing out that you can't get an adequate remedy at law because this is a solely private trust that is solely in equity jurisdiction alone. And that's the touchstone for equity, that there is a lack of an adequate legal remedy. So it looks to me like we've got, if we put in the right pleading verbiage and bring in the right evidence in chambers, they have got to recognize this as being an equity. And equity is not the power, but equity is the force that will enforce your power, and your power is the ability to choose whether you are making a general deposit under debtor creditor or whether you made a trust deposit and therefore it's trust under equity.
Question.
Yeah, Michael. Go ahead.
Well, the thing is, when we do the in-chambers, okay, should we just send all that information right to the judge right up front to show him that this is all special private trust, you know, show him our law, what we go under, which is Scripture, and then also the Declaration of Independence, all up front. Let him see them.
Yeah,
and then, of course, put a protective order saying we need a protective order because we're here to protect you. We can't disclose this in the public court, and we cannot get we can't go by your public law and get remedy. We have to do this in private chambers. And hopefully, with him seeing that information, then he'll won't disclose this, and then we can go in chambers and resolve the whole situation.
Right. So,
hey, Christian, what about doing an indenture, placing that into a UCC as a public notice that your intent as grantor or co-trustee to the Bankruptcy Act is dictated as follows, and have that on public record? For particular cases like this, that can actually be assigned to the case to clarify the intent of the grantor or seller or co-trustee, depending on which angle you want to use.
You mean the actual indenture itself recorded into the public notice?
Yeah, either privately or publicly. We've, with the if you wanted to do it privately, that's fine. But as long as it exists, you can have that assigned to the case that clarifies that on such and such a date, 3.5 years ago, this was the intent of grantor or co-trustee in regards to the Bankruptcy Act and the trust that was set up therein. Here is where I'm at with living in life in America. Everything's a trust, and this is the way I look at it. So therefore, I conduct my activities, blah, blah, blah. And so therefore, if there's a case that comes up in court, you've got those papers that have been on record without anybody disputing or even rebutting it. Therefore, it stands as truth. It's like an affidavit.
Yeah, here's my question. Would that be actually giving back into the public the privacy of the trust and actually waiving the trust then?
No, because if you attach an identification number to that and only file the identification number with just a brief comment that this indenture exists on the private for any person of interest that wishes to view this, can view this in the private. Therefore, that would be the statement along with the identification of the document that you would post on the UCC-1.
Okay, maybe you misunderstood me. I was saying, do you actually record the actual indenture instead of a notice?
I would probably have it notarized just to have a second witness, but no, I would not probably publicly show the document.
Okay, that's what I misunderstood then. Yeah, because I kind of think that just a public notice of an existence of, say, something exists in a private, and nobody really knows what it is in a private, although it's a trust indenture.
Yes, that's how I would probably do it right there.
Okay, yeah. Yeah, I'll agree with that, yeah. I thought maybe record the actual indenture into the public, and I think that would be waiving the privacy and making a public trust, and that would probably waive the trust.
Could I add something?
Yeah, who's this?
Jacob.
Jacob, go ahead. Yeah.
You know, what I was trying to say, and I probably didn't say it correctly, but it's like a IRS situation that most people are in. And they get something, you know, from the IRS, they get in big trouble, and then they start working on this big presentment and this big case, and they've got everything done. They just went out and spent $200,000, everything. They got all their statutes and codes. They got the I's dotted and T's crossed, and they go in there and they present their case. And after they're all done, the judge says, well, give me about 5 minutes. He goes back into his chambers. The guy comes out from the Federal Reserve, shows them the signature card where they hooked them into the master agreement to promise to pay taxes. He comes back out and he says, you lose.
Right, yeah.
That's what happens to you guys. The first thing you got to do is know who you are when you're standing there.
And who is it that you're supposed to be?
Oh, if you're not somebody that they have any authority over, you're going to be special. You yourself are going to be special circumstance.
Yeah, if you're not grantor or some other trust position, you're in their jurisdiction.
Well, what about you know? What
creditor,
about,
or you're a secured party creditor? You're under debtor creditor, and you're in the room.
Right. You're not going to get anywhere. But I was thinking that if you're going to grant and convey, get this thing out of the so-called target zone, and you're in a so-called, you know, a trust, and your trust, and someone that comes in there is the trustee of the trust, just like they have what they're doing. They're sending a lawyer in there as a trustee. Guy has zero standing. We just don't know how to remove him. And so, you know, you should never get in that position anyways, because that guy should never be allowed to walk into the courtroom if you know what you're doing. He's a representative of a servicer, a third-party debt collector, who's nestled like a Russian
How do we challenge jurisdiction of the at-law side? Anybody? So if we're under the at-law side, we're in there as usually as defendant. What are we going to do to change the situation? Change the nature and character of this.
Well, you're going to have personal subject matter and personal jurisdiction and subject matter jurisdiction both. Most people only understand subject matter jurisdiction because they don't know personally who they are to begin with, and they don't know how to get out of it because they're actually in it. So I think for most people listening, it would be more subject matter jurisdiction that you could challenge.
Well, how are you going to challenge that?
Well, you're going to challenge that on the basis that they have no legal standing, that they would have to identify their position, you know, flip it back on them, that they'd have to identify their position. And you better be able to have records and proof that they are not who they say they are, so that if the judge is having a bad hair day, you can have those records as proof.
Well, let's say that the IRS guy comes in and he's making allegations. They got jurisdiction over you, and you haven't paid your taxes. So who's got the burden of proof?
Christian, if you've contracted with them to pay the taxes, you're going to be paying the taxes. If you haven't contracted,
what I'm trying to make was the point was that you know, on this tennis match game that they're playing, that you're going to lose on.
Right.
You know, how does this thing play out? Because they served you with this 140-mile-an-hour ball, you know, that they whacked on you. Now, how do you return it?
I would say, could I say what I would say?
Yeah, go ahead, Floyd.
Your Honor, I am the trustee of this trust. As trustee, I don't have to reveal who the beneficiary is, and I know who it is, and it's not you. You want me to give you my name, and I will give you my name in confidence with reliance to be returned in the future, along with the proceeds therefrom with my interest.
Okay. Anybody else?
Yeah. You remember on Saturday night that I had mentioned that one of my local groups here confirmed the information in the, I think it was either the Securities Act of 1933 or was the National Securities Act. I can't remember exactly which one they were pointing it out to me, but there are only two true creditors. That would be the IMF/U.S. Treasury and or the person that's signing the documents. And by being a true creditor, if your intent is not to enter into either contractual agreements and or trust, there would be your standing or your position on that type of a situation you're describing.
Well, there's going to be several degrees of compliance for subject matter jurisdiction. You could just alone, apply for what is it, the B-132 from the United States federal bankruptcy trustee over all the United States and all the courts.
Yeah, but now we're traversing in on the facts, and we're traversing into the case because we're arguing the facts. I mean.
Okay.
That they want to get you into because they're going to take jurisdiction around over that. As soon as you start talking about the merits, arguing the merits, the facts of the case,
okay.
They got you.
Okay.
How do I challenge jurisdiction and get myself out of being the defendant? Come on, guys.
That's the key. That's the key.
Yeah, well, how do I change that status? There's me being defendant, being presumed to be the defendant.
Well, the way I would do it, I'm not under their jurisdiction. I don't have all that stuff you guys have, and I've already been accepted by the government to be under my own law form myself with my family.
Let's say you're normally like everybody else that's got everything else, and you're how do I break this presumption?
Well, is expressing the trust and having the documents for all the trust and have it already into the court record, not the court record, but into the judge chambers. You have all that stuff already put into in chambers, and there's your proof right there. It's a trust. So you're no longer arguing their law form. They have to come into your realm now, which is equity.
Yeah, I'd say that's part of it. But then, we discovered something just recently within the last 3 weeks or so.
Does that have something to do with the Administrative Procedures Act, or a little bit like Bill Thornton? He says that the way the laws are written, and because we're not a party to their statutes and codes, we always remain as the plaintiff. And I know that there's some language in the Administrative Procedures Act that also identifies that the living sentient being is always the plaintiff in any charges.
What gives them jurisdiction? Anybody?
Well, what gives them jurisdiction is because it's in a general deposit, and we have to take it out and put it in a special deposit.
There you go. That's what I'm looking for.
That's the one?
Yeah, how do I change the nature of the deposit? If the general deposit got you to be the defendant, how do I get out of being the defendant?
You take it out of general deposit or the special deposit.
And withdraw it from general deposit and redeposit it under special deposit. You just took yourself out of at law and put yourself into equity.
Could you do that right in court if you got caught with your pants down?
Yeah, you probably could, but remember, it's looking for on the face of the pleadings and evidence.
You better have some underwear on.
Yeah.
We'll leave that one to you, Michael.
So if we're going to put something on the face of the pleadings, we're going to claim, hey, there's a trust here, and then we're going to have the evidence to prove the trust.
Now,
and then we're going to have evidence that shows that we made a withdrawal from general deposit jurisdiction at law side and a redeposit into equity under special deposit.
Well, couldn't we put that in our indenture when we file a private copy of that on public record that it exists? Can't all that language actually pre-exist that ever when you need those sets of documents?
What would be the information that we need to prove a trust? I don't really have an indenture.
Mm-hmm.
No, it's already on the UC3, Chris, and that's your evidence.
Trust. What proves trust? When was the trust formed?
As soon as you sign, or as soon as you create it.
Well,
no,
trust
is formed when the res is accepted and delivered to the trustee.
Right.
That's right.
That's right.
But don't we have to exhaust first the at-law side? Because
no, there's no adequate remedy at law under trust.
Well, here's one.
You can't exhaust it. It's debtor creditor.
Here's one here under the Florida Rules of Civil Procedure, Rule 1.140B1, which shows, 1, this court lacks subject matter jurisdiction to proceed. Subject matter jurisdiction has never been established on the record. The jurisdictional question can be raised at any time and can be time barred. That's Declare versus Yanahan 453 SO period 2D 375 Florida 1984. This court should dismiss this action pursuant to Rules 1, 210A and 1.407 of the Florida Rules of Civil Procedure because the record is clear from the promissory note submitted as evidence that a person other than the plaintiff is the true owner of the claim sued upon and that plaintiff is not the real party in interest and is not shown to be authorized to maintain this foreclosure action. In Florida,
okay, yeah, we know all that. Let's jump on here to this.
Okay.
The section here under the action to enforce the pre-annexation agreement, which I read twice, where it says the villages, an entity, a plaintiff, probably was the villages. The villages' action seeking to enforce a provision of pre-annexation agreement was improperly dismissed under theory that amended complaint was deficient. It was deficient because it did not make alleged facts demonstrating that the village had no adequate remedy at law.
And where's that?
Page 179 in the footnotes.
Okay.
In corpus juris secundum.
Okay.
Jacob.
Yeah.
The thing is, you're going at the angle at the at-law side, and what we're trying to do is pull it out of the at-law and get into equity. Now, when you're going, now let me finish. Now, when you're doing the jurisdiction, sure, you can probably win if you have all your ducks in order majority of the time. But the thing is, why do you want to even go into the court and go that route? To me, the simpler thing to do would go into in camera, have all that stuff already presented into the the court, the judge's chambers, and at that point in time you have no controversy because you've already proved your point. I hate going into court, and I know you do too.
But didn't we say that you have to you have to whatever the word was, you have to extinguish all your remedies at law before you can
here's what it says. It says an equitable remedies cannot be pursued until legal remedies have been exhausted.
Yeah, so that's what I was trying to do, is bring out the legal remedies that we're going to be that we would be faced against.
Yeah, but there's a caveat with that. It says it is sometimes stated. The rule is sometimes stated. So it's not 100% that you have to have exhausted your administrative remedies. If you have no administrative remedy available to you at law under trust, then there's no adequate remedy at law, period. And that is, by default, 100% a jurisdiction of equity under trust, a private trust.
But wouldn't the judge be sitting there and thinking to himself, well, there is at-law remedy, so I don't have to let him into equity?
Well, that's what this case is, I'm trying to point out. This action to enforce the villages said that it did not demonstrate that the villages had no adequate remedy at law. You've got to demonstrate that there is no adequate remedy at law, and then bingo, you're in equity. If you don't demonstrate that some way with evidence.
Can you post that thing somewhere so we can have it?
Well, there's only like 3 lines. There's nothing really to post. Just go get the book 30A of CJS, and there's section 18, and this is copyright date on this one is, let's see, $1992.
And is one case enough, or do we need 2?
Well, under this heading, there is a case in 1, 2, 3, 4, 5, 6, 7, 8, 9. There's nine cases under that.
Oh, okay.
There's a California case.
Really?
Talafiro versus Talafiro.
You know, you cite those cases, and then
T-A-L-I-A-F-E-R-R-O versus Talafiro. 300p second, 726, comma 144, CA second, 109.
Thank you.
It was denied, and that was at 77. The Supreme Court, 355, and also at 352, U.S. 971, 1 LED, the second, at 325.
Okay, thank you.
A comment, Christian, going back in our history, you've said it more than once, so I really actually took note of it. And that is that because there is no lawful money in existence, there is no remedy at all.
Yeah, but that would be probably a tough one to prove, because that would be a public policy shock, and they probably would never allow that one in. That's too much truth. So. Okay, Pete, come on in.
Oh, hi. Thanks. I'm just reading classification of equitable obligations. So if they've statutized equity and we're trying to come in at true equity, then I agree with everything that you've said about doing everything, you know, specially. But at the same time, I think that, well, especially for me, I'd need more experience of how to operate in the court before I could do that.
Yeah, I imagine so. I wouldn't just want to walk in cold turkey without being prepped somehow.
Yeah. And then I think absolutely correct as well in saying that you're never getting a remedy at law anyway, whether you're given the illusion that you are or not. But I was just reading some quotes on equity, and it was saying,
you know, the point I was trying to make out, the lack of an adequate remedy at law is really, it's trust, and there cannot be any adequate remedy at law because trusts don't operate at law unless it's a statutory trust.
Yeah.
So it's like we're in like Flint.
Yeah.
All we have to do is, by the facts alleged, demonstrate that there is no adequate remedy at law. So we'd have
Which
to
is
prove
a question.
Trust, and on the face of the pleadings, state that there was no adequate remedy at law, and then put the elements to support that claim, and follow it up with the evidence in chambers with the SOIs in chambers.
Christian, isn't presumption in public policy a big factor that has to be addressed in order to show that there's no remedy at law in order to move it into equity?
Yeah, I think generally everything is considered to be a general deposit unless proved otherwise. So you're under the jurisdiction by presumption until you come back in and present some kind of evidence to break that presumption, and now they can't really support any evidence to come back at you with to shift their onus from probandi back on your part again, because you rebutted it with the facts to substantiate that this is a trust. It's not even in your jurisdiction at law, can't be under your jurisdiction. I can't get a remedy on your jurisdiction anyway, and I'm under equity, a whole different venue.
Would you need to put on your notice that it was special trust?
Well, private trust would be special, would be exigent circumstances.
So you would put that on the notice?
On the notice?
You know, on your UCC1?
No, I don't think I put it on the UCC1 or the counties. I may put it in facts that I'm holding in the private.
Yeah. Yeah.
And just the fact that I am holding a private trust, that is special. That is exigent.
Cool. So you've pretty much covered all angles in that respect then, haven't you?
Yeah. Well, let's hope so. But we always have a tendency to make things more super difficult than they really are, I think, and we actually jumble it all up ourselves. Usually when the judge says, I can't grant that, you probably can't, because we screwed up somehow.
Well, they have a saying in England that the law is an ass. And it generally means that, no matter what comes up in the court, it's never set in stone. It's always open to negotiation.
Yeah, that's the deficiency of the at-law side.
Exactly.
But under equity, we got cut and dried rules. They're following maxims, and that's it.
Yep.
And the combinations is, I forget what I was reading in here, where it was saying there was, there's a sharp and distinct, but a variable and changing line between law and equity.
Well, equity seems to be, according to the book I'm reading, all about obligation.
Yeah, it's duty. Right.
Yeah.
It's all about a right that fellow owed me, and he didn't do it.
Yeah, and there's a distinct difference right there. When you look at codes and statutes, that's a privilege, not a right. Yeah. So therefore, the presumption is that your debtor-creditor relations to that particular government, and otherwise you would be deemed as special with rights that wasn't subject to the privileges.
Hey, Christian, can you hear me?
Yes. Is this Shane?
Yeah, hi. I kind of got in late, so I was just kind of following along, but obviously you guys in the jurisdiction thing. I think this is almost like, really, to me, it's like a topic of almost general jurisdiction, which I have learned, or from my own personal thing, is I think it's more subtle than most people think it is. But
in fact, it's so subtle, it was in a presumption that you are.
Yeah, exactly. And I think one of the first things you got to do is that's got to be established as soon as you say boo. And if you're not arguing about jurisdiction as soon as you introduce yourself and moving into it, then you're probably already in jurisdiction. If they're ignoring you, you're in jurisdiction.
Yeah,
if
you're arguing facts and merits on the case, and you've traversed into the case already, and they got jurisdiction under a presumption already.
Because I figure
that fact. You establish the fact by arguing the fact.
I mean, yeah, I really think people could just go to learn. I mean, it's.
But we're not talking about how to argue jurisdiction. There is no question about jurisdiction. That's the point we're trying to make here.
Well, and even the phrasing, argue jurisdiction, that doesn't make any sense, right? That's almost an oxymoronic concept, right? You can't really argue jurisdiction. If you do, then you're already suckered into the game already. And again, they beat you again. I think the only thing that I ever did was, and I don't know all the stuff. All I know was how to stay out of it. And the only way I knew how to do that was I didn't step over the line, because I had a criminal defense lawyer saying, it's okay, you can step over the line, it's okay, you can do it, the judge. So I knew not to step over the line, right? And if need be, if I had the opportunity, apart from saying I'm here as the grantor and trustee, and maybe that's not the right thing to say, maybe I'm there as the grantor and beneficiary and want to appoint the judges as a fiduciary trustee, maybe. But the whole thing is, I'm telling you, I think the mindset is you have to speak in questions. If you can train yourself to speak in questions, I really honestly think your whole thinking just completely starts to change, and the attitudes change.
The answer is you're just asking questions.
Exactly. I'm not in jurisdiction. You know, I'm not even here. I don't really recognize this court. I'm only here because I'm aware that if I don't show up.
When did you come in? How long have you been on?
I've been on for, I got on around about 25 after, I don't know, about 25, I guess I've been on for 51 minutes now, so.
Well, 51
minutes? I was about 20, 30 minutes late, yeah.
Okay, so remember we were talking about on the face of the pleadings and from the evidence?
Well, I'm wondering if you guys are even getting the opportunity to I kind of caught some of that, but I'm not completely sure where you're going. But what I'm thinking again is I think this thing is I know for a fact that if you try to say that you're outside of their jurisdiction, and if you're doing it effectively, the whole battle from that point on ain't going to be about anything else except for the jurisdiction. So that's a pretty clear sign.
We're not, how we're trying to set this up is we're not there to argue the jurisdictional matter. We're here to point out the jurisdiction is equity.
And I think you still have to do it from the point of if you make a statement is a form of jurisdiction itself. That's why I think you have to say it in the form of a question. Like, am I not to understand that this has already been settled into private? Do you understand that I'm only here on discovery? You know, this kind of thing. It's as simple as that. And if you start making, as soon as you, I really honestly believe as soon as you make your, I mean, I'm sure there's an exception somewhere and in the right context, but I'm not that fancy yet. And so all I know is I know they can't touch me if I put it in the form of a question. And it's not hard to speak in questions. It's not. It really isn't. Any statement anybody can make, I can turn it into a question. And everybody should practice it.
Okay. Now how do I get in the court of equity?
Have you ever won? Have you ever won doing what you just said?
Yeah.
Yeah.
Yeah. If you guys have been listening, I've repeated this a million times. But anyhow, yeah.
Well, that's what I mean. You keep repeating it a million times. We're talking about trust here.
So wait, what was your first question again, there, Mikey?
Well, let me ask you this question, Shane. How do we get into a court of equity?
I am not sure, but if there was a situation where I said, you know, with the limited knowledge that I had, it was 10 months ago, I'm still analyzing the thing, but I said, you know, do you understand that I'm here as the trustee and grantor, in fact, with special interest? I said that for the purpose of getting past the
name. That might be an NOI statement that gets you to claim a trust.
Okay. Now, the first thing he did was he didn't roll over and get on his knees and kiss my butt, as everybody's fantasy is, okay? He got up and he walked out and he came back in again and he made an adjournment. Now, I have since found out that somebody else did something similar and they got a similar response. And then I think Dick just did a conference call.
How do we get into a court of equity? I don't want to argue jurisdiction on their part.
This wasn't an argument. But he didn't argue with me either. He was just asking me questions too. And the first question was, of course, who are you? And then I said, do you understand? Which is a question, wasn't a statement. He got up and he left and he came back.
Keep on reiterating your battle with the at-law side challenge of jurisdiction. I don't want to go there.
Yeah.
I want to.
Well, hold on. He didn't argue anything. But yeah, you do. So you know what it means when he gets up and leaves and comes back. That's right. He's trying to restart the thing because he lost on the first one. Okay. But then all he did, apart from
the fact I'm trying to point out is we've all been trained to argue jurisdiction, and we want to stop arguing jurisdiction because they don't have jurisdiction, and they're getting you into the jurisdiction by arguing. I want to point out the fact that if we stop arguing jurisdiction and make it clear to them that this is an equitable proceeding, and here's the facts to substantiate that, you don't have to argue jurisdiction.
I agree with you. I would agree with you. But, I mean, how much arguing can you do if you're only asking questions?
Yeah, but that's not getting where that's going around and around and around.
But I think if you know how to ask the right questions, if you know what your focus is, could questions not be used to focus exactly on what you want to deal with?
Okay, how do I get into a court of equity?
Could you not even ask the question, is there a court of equity here? And do I not have a right to have access to it? And do the circumstances not necessitate the need?
Now you're starting to on the chain.
For private chamber one. Yeah, for a private chambers hearing. I mean, that's, you know, I can think of questions.
Your questions towards equity, challenging why you're not in equity, why they're not recognizing that I am in equity, and that's where the jurisdiction really is.
Yeah.
And I've nothing really to talk to them about.
Yeah, so you got to know what you're trying to do. You got to have an assumptive position, and then you got to be like, yeah, like, why aren't you guys listening to me? Why aren't you paying attention to what I'm saying? How come we're not on this? You know, I think questions can go wherever you want it to.
You to argue their jurisdiction when you need to be asking them the questions, it gets them to argue your jurisdiction.
Exactly. Yeah. I mean, I don't recognize their jurisdiction. That's one of the components of my position standing there in the first place. I'm there under duress.
They keep on asking you the questions, and they want you to answer them. But here's what everybody's getting. Here's what everybody's not getting. They want to get you, the new thinking out there today is that you got to ask questions to challenge their jurisdiction. No. You want to ask questions to substantiate your equitable jurisdiction.
Yeah, you got to put them on the defensive.
Yes. So we're asking the wrong questions because we're asking questions that are at-law jurisdiction based instead of the equitable trust-based.
Sure. Like I told her, I said, are you telling me that I don't have the right to be a trustee and grantor, in fact? Like that kind of question.
Those are the questions we need to be starting to model and come up with. Because instead of saying who we're not, we're saying who we are.
I guess they're hinting too when they say I can't see you, or we can't deal with that, or we don't see that. They're kind of hinting too, right?
Yeah, because you're not in their jurisdiction.
Right. So that right there, wouldn't that be a bit of an opening towards an equity position?
Well, how could I prove that this is an equity proceeding?
If you got a judge saying I can't see you, so you turn around and I guess I'd be a smart ass a bit because of lack of practice, but I'd say, well, so what are you saying? Are you saying you can't deal with this issue? Are you saying this is a non-issue? Are you saying it's irrelevant that you can't see me? Is that you know, because you're making a statement you can't see me, so there must be some relevancy to it. So what's the issue here?
No, but
how do we get around this?
Perhaps you could say, can you see me in equity?
There you go.
Okay, but
maybe that's what it is.
What is the basis of the equity?
Sorry, what is the basis?
Yeah, what is the basis of the equity?
Well, I'll let you paperwork guys help me out on that, but I'd imagine it's
trust.
Your trust. Yeah, and you need evidence of that now, right? And that's your UCC 1 and 3s and stuff?
And we need something on the face of the pleading, and then we need something from the evidence. That plaintiff has no adequate remedy at law. And we must make some kind of alleged facts demonstrating that there is no adequate remedy at law.
Now, Christian, when you say that, it's the way that's structured, as I recall from the way you're reading it, that there is no adequate remedy at law. It seems to be an obverse statement in the sense that, you know, it's like a negative statement, but if we come in and say, well, look, these are the maxims of law that have been breached, you have unjust enrichment and whatever else we can come up with, aren't those the equitable proofs, those are the proofs that we would need to establish the pleading?
Yeah, what are the factual circumstances here?
Yeah, so we
said that earlier.
Right.
You can remember what it was.
So we bring those in, and then without going into, it just seems to be the information we need is right there under the maxims, because the maxims are the things that control the claiming of equity.
Yeah, but the maximum of law is what CW has said is a scripture. That's where the maximum of law originally came from, and then you're bringing your law into the court, into their jurisdiction. They no longer have jurisdiction over you. And the thing is, arguing jurisdiction in front of a judge, I truly don't want to do that. And maybe some people feel that they can get off and have you sit there and keep asking questions and creating a controversy, because if you know Scripture, you're not supposed to have controversy. You're supposed to try to
Mike, if you ever actually tried asking questions in a court, it wouldn't create an argument. If you actually really practically try it, you should try it and then make that statement.
I'm making the statement.
That doesn't.
Yeah, hold on, guys. Are we actually making questions that we're getting someplace, or are we asking questions, that aren't getting to the heart of the matter? And really, what is the matter? And I think
Christian, if you had, sorry, go ahead. If you had protective order information, could you not go into court and say, I have some information that's under protective order. How can I proceed with this? Is that going to create a big argument?
Yeah, but Bill, are you still on?
Yes, I am.
Yeah. Do you remember what you were talking about, which would demonstrate the factual circumstances? Do you recognize what that might be?
As far as the maxims?
You mentioned it, but I don't know if you realize what you mentioned. It was really talking about factual circumstances, what you mentioned.
You'd have to. I don't remember. No.
It's a difference between equity and at law. What is the issue between the two? For equity to have jurisdiction, we got to be talking about something that they've got to recognize.
Well, there's no remedy. We know that, but I can't call it right now.
Was it something to the effect about exhausting all your remedies?
No. It was rights. Equity has to do with rights.
Oh yes, right. That's the whole thing. It's the trust is there to protect the right of the beneficiary.
That's the whole key, right? That's the factual circumstances for equity. Because trust is talking about a right.
And the other side is talking about a privilege.
Yes. So there cannot be any adequate remedy at the at-law side, because we're not talking about anything that's a privilege. We're talking about rights. And rights operate solely in equity.
So that's why we're high on the Bill of Rights, equity.
Right. The Declaration of Independence. The Declaration of Independence talks about, I think in the first paragraph there, talks about the law of nature and nature's God. You know what that is? In the beginning of equity, when we start talking about this equity, right on the first page under the general considerations, under the section, let's see, which section was that?
It says the same thing.
Section 2, which was definition and nature. So the nature of equity,
right.
It said under the footnotes, it said the law of nature. Equity was once known as law of nature.
Right.
Guess what the Declaration of Independence has right in the first paragraph there? The law of nature and nature's God. The Declaration of Independence is talking about equity. because equity is the law of nature. And really, it means equity.
Is there some kind of process, though, where you have to accept that as a trust before you
Well, no, there's
effect?
really no acceptance under trust. It's a likened to an acceptance, but it's a declaration. It's not an acceptance. Acceptance, except for value, it's all debtor creditor. What is like the acceptance is declaration.
So
We're
now,
the only ones who can declare. Declaration of independence. Declaring your independence. And we're operating under equity, the law of nature. Nature's God. But today, there is no equity in the court except in chambers, and they don't have the commandments in the Bible in the courts. They've thrown it out on the at-law side. Therefore, there is no adequate remedy, because the remedy you want is the enforcement of a right, not a privilege. And we read in Lewin under page 19 where it said that equity is the sole jurisdiction of trust. So if we want to enforce a trust, which is rights, it's got to be in equity, and then there is no adequate remedy at law. By default, we are in equity already. It's just that we've got trouble of getting them to recognize the rights that we have. Because we want to get in there and argue that they don't have jurisdiction instead of telling them this is an equitable proceeding and here's the facts to support it.
Christian.
I think somebody else. Chris, were you in there first saying something?
No, that was me.
Jacob?
I just while you're on that subject, can you give us your lifelong nutshell version of comporting rights to the law of nature? I mean, I don't equate rights to the law of nature. When I think of the law of nature, I think of
No, I don't say that. I say exactly what the Declaration of Independence says, which is directly from Scriptures. It says that those rights were given to me by God.
Christian, I just heard from a conference call that was confirming about, like what I was trying to get in earlier, about when the judge leaves and he comes back, that not only did he lose in that first round, but he's creating a different court. Mm-hmm. And I think they're a little bit more liable in that second version. And apparently, if they left a second time and came back in a third time, if I'm not mistaken from the language he was using, I think that's your equity there. But just to keep this all in perspective, and before we go into the hypothetical, I don't think or heard of a judge leaving twice and coming back a third time. But I think when they're there, they're at their highest level of liability, and if they make a mistake at that level, I think you can call them on it basically. I just add that.
Strikes into the three strikes rule, and then the court's in a dishonor.
Yeah, well, but not only that, they're in a court of, I think you're talking about this, the biblical court as well.
Did he come back in with his robe on or off?
Well, I don't know, because this is it. In practice, I've never heard of a judge leaving twice and coming in a third time. Usually they cut it, like when the judge came in on the second time and then asked me again, despite the break, I'll skip over that part. So basically all they said was one line. He leaves and comes back and says, comes back as quick as he left and says adjournment. So we'll skip past the adjournment for all practical intents and purposes, come back into court, and he starts right up again. Okay, second time. Who are you? And I said the exact same thing. This is in the criminal court on the second visit. And because I didn't know to do anything else. And then at that point, he was just put his hand up, all right, don't say anymore. And he was operating as my trustee as far as I'm concerned, because he was clearly operating in my favor, and he was going after the prosecutor. So I don't recall any argument or fight or whatever. I didn't even know what was going on.
If he lost on that one, he would have gone into three strikes, and then if you know what you're doing, he possibly could be liable then, yeah.
He just didn't want to waste the time, and there was people there, and he didn't want me speaking up. So he just, and the cop wasn't there, but they never dealt with that. He just went after the prosecutor and started on her like, well, listen, you know, you're the prosecutor. I'm the judge today.
And not going down the track that ends this thing, because that's no remedy at all.
My thing is this, though. What's easier, to jump into a box and then try to get out of it, or to avoid jumping into the box altogether?
Well, everybody wants to take the 98% success at law when that is no remedy completely at all. That's like a dog to its vomit going back thinking that you won and you won nothing. Now, I would have pursued on a different track. I would go into equity and get them on a breach of trust and pursue that until that was the ultimate. Now I can. That's in a place I can win.
So that's in chambers, or if you came back a third time kind of thing. It's got to be like ultra.
Yeah, I want to get them to enforce what I came after, not to get them to trick me to take some other lesser deal. I want enforcement. I want them to do what was required of them, whatever the duty or obligation was, because that's what they're doing to you.
So what you're doing in a way is you're shifting titles between privileges and rights.
Yes, I don't know if you guys see it or not, but the withdrawal and redeposit is nothing more than a merger of titles. The merging of titles would be the extinguishment of the lesser contract, the debtor-creditor relationship, and the higher, the security of the trust. That's merging titles. That's all we're doing.
Another avenue besides trust in the CGS is trust and also fraud. Fraud is another portal for equity jurisdiction.
What was another portal for equity jurisdiction? The
fraud.
Fraud.
Yes.
Yeah, because if it was based on a duty or an obligation, yeah.
Well, I'm just saying that as I remember reading in the CGS, I think there were 3 or 4 different specific areas. One was trust, one was fraud. I don't know. I don't remember the others, but.
Yeah, I do remember that, yeah. Omission.
Okay. So that, I mean, I'm saying that to say that goes towards your question about, you know, what are the grounds or what evidence or what are the pleadings or the claims we have. So, you know, we have trust, we could have others as well.
Yeah, trust is not the only thing that operates in equity, I don't think. Unclean hands, that's equitable. Injunctive relief, that's equitable.
But the unclean hands, that's okay. Now that's a maxim, right?
Yes, right.
So then, how do you use that? Is that like is that a pleading?
Well, that'd be a cause of action, which is colorably recognizable because that's in their at-law side.
Right. So that's a cause of action. But it's still just.
Pleading.
I'm sorry,
I was just going to add, pleading would be a form of giving them jurisdiction, I think. That'd be like testifying and making statements and all that.
Yeah, I think you're right.
We can't plead, we can't petition.
So then, if that's true, Mike, then
corporate stocks put in a bill of equity. We put it in the bill.
Right. So what Christian was reading is really statutory stuff, and that's stuff that we have to know not to use.
Yeah, right. And we are steeped in statutory stuff. We're steeped in debtor-creditor verbiage. That's all we know. And a lot of the terms and things that we use, we're using at-law side terms.
So would you say it would be a bill of equity, you would say? That's what we would put in?
That's what it says. Ordinarily, a bill in equity.
Okay, but you were reading the pleading stuff, you know.
Yeah, that was under the same section. Lack of remedy at law as ground and a limit to jurisdiction. It says, as a rule is sometimes stated, equitable remedies cannot be pursued until legal remedies have been exhausted. And ordinarily, a bill in equity cannot be maintained to obtain precisely what plaintiff can secure by an action at law. But there's other places where it talks about a bill in equity, bill in equity. Even Lewin talks about bill in equity.
So then basically it depends, I guess if we go as debtor-creditor, then we're looking at being on the at-law side. If you come in with a bill of equity, a claim of equity, using the equitable language, then that just makes the major difference.
Yeah.
Is that what a bill of equity is? Look at it like a proposal or a claim?
Well, if you look at the definition of Black's Law under bill of equity, it is a pleading. That's what they define it as under.
Well, we know we have Black's Law.
Elements in it as
Black's
pleading.
Law. But I wonder if it has a trust underlying connotation as well, though.
Well, if your cause of action is a trust, then
it's kind of a funny term, right?
The pleading that is give the NOI. It's going to make the court cognizable of the equitable claim.
Now, another thing about trust is that it differs from the at-law side. And trust is the substance, whereas the at-law side is the form.
Okay, let's go on to this here. We're talking about the theory that the rule is that equity will not take jurisdiction where there is an adequate remedy at law, and is to be taken as indicating the origin of equity jurisdiction as defining generally its grounds and objects, is more generally adopted than the theory that the existence of an adequate remedy at law is a constant limitation on the exercise of jurisdiction. Whether the latter theory prevails, the courts in adopting it have generally been influenced by statutes in terms restricting equitable powers into cases where there is no adequate remedy at law, but in other jurisdictions, such language in general statutes is held to be merely descriptive of and not intended to restrict equity jurisdiction and is not precluding the broader doctrine. And now the rule that equity will not grant relief where there is an adequate remedy at law applies only when, on the case stated, there is a legal remedy. A distinction is to be observed between a case cognizable at law, but for which the law has no adequate remedy. That would be trust. And a case that can be adjudicated on the merits only in a court of equity. In the one, equity court is invoked only for a remedy, and in the other, for an adjudication of the rights of the parties on the facts. Where the suit is properly cognizable in equity, the existence of an adequate remedy at law may justify a court of equity in refusing to entertain the matter where the matter is legal in nature. The absence of an adequate remedy at law is necessary to confer equitable jurisdiction. If on the facts stated, the case is of a nature cognizable only in a court of equity, there again trust, plaintiff will not be shut out of that court on the suggestion that on another state of facts he might recover that which would be equally satisfactory in another tribunal.
Christian, will it matter for the plaintiff or the defendant trying to get into equity?
What was that, Shane? Jacob?
Will it matter if we're the plaintiff or the defendant to get into equity?
No. If the defendant has an equitable claim, he can get into equity.
So is that the key idea, the equitable claim?
I believe the key is that really trust operates solely under equity, and there is no way other than it's going to be operating other than in equity.
So what would be able to trip us up where the judge could construe it to be a statutory trust to preclude us from getting to equity?
If it was a statutory trust, you'd be able to talk about it in public, wouldn't you?
Yeah, that's right.
If we have anybody who wants to ask any questions, you're going to have to press *6 and *1 to get in the line. If you don't press that, there's no way in heck that I'm going to know that any of you want to ask any questions. Because the only ones we got in here that are asking questions are the 4 on the board here. Now, if anybody else wants to ask questions, get in the line.
Christian?
Yeah, Pete, go ahead.
I'm just wondering about the validity of an equitable lien. Does that come into play at all?
Well, what about an equitable lien?
You know, there's such a thing as an equitable lien. Well,
yeah, for enforcement and equity, yeah.
Yeah, if we've got an equitable claim and then we bring an equitable lien to the court as a claimant, I'm just going on the back of Jacob's question there. It was quite interesting where usually we're coming in as defendants trying to go into the chambers, but he was saying it doesn't matter if you're defendant or claimant. So I'm just jumping here, piggybacking on the back of that, saying that if we've got
let's mortgage foreclosure. A mortgage foreclosure is an enforcement of security agreement, which is a lien. And that's where they're going. They're going into equity to get the enforcement to get you to force you to pay. They're taking your house by operational law.
In regards to Pete's question, with an equitable lien, or claim, does it matter? I mean, are we going to be negotiable versus non-negotiable?
Non-negotiable or negotiable?
Well, if you have an equitable claim or an equitable lien, if we have a counterclaim, we have a claim against them for proceeds that are to be returned, and we're going to be going into equity, how do we handle that in the format of a negotiable, colorable side of the claim as opposed to a private trust, equitable side of returning to us the interest, payments from the escrow deposit account or whatever else? When our special deposit is a non-negotiable thing. So when we order them to give us back the payments in the deposit account and the interest in the special deposit, the interest from the securities from the special deposit account, how do we convert our position to receiving something in a negotiable form when we're giving them a non-negotiable thing to extinguish the title obligation that they're holding?
Well, they're going to do the conversion if necessary.
Don't we have to tell them?
I would imagine so.
So what am I going to say?
We'll convert, if necessary, a special deposit as needed.
Into what form?
Whatever form necessary to achieve the extinguishment or the discharge. Just give them an order, direct them, command them.
But if I direct them to do it in currency, Do I waive my whole case?
Well, we're kind of getting off point, but we're not talking about collecting. We're talking about getting into court of equity.
Okay. I'm just trying to visualize I'm in there, and then what am I going to do? Where's my head at? And I want it to be, focused on the reasons why I'm going in there, along with getting
titles with the equitable asset with the debt title. Those two should extinguish it. That would just be a merger. I'll tell you what would make it a little bit easier. Let's just end the Q&A, and if anybody wants to ask a question, you're going to have to press *6, unmute. Yeah, turn the Q&A off.
Q&A session is over.
All right, press *6 to unmute to ask a question. Anybody have a question?
I do, Christian. About equity. About equity. I really, really, really would like to understand how equity is natural law. Natural law, nature, natural law, because equity, the way you've taught it is basically like justice and fairness, is it not?
Right.
Okay, so how am I gonna look at that in the face of natural law?
Well, the equity that they're going by in the courts is the maxims. So go by the maxims.
Okay. I'm gonna look those up right now. I got them.
Christian?
Yeah, go ahead.
Yeah, this is Joe from Southern Nevada.
Yeah, Joe.
Article, the 11th Amendment of the Constitution, it says, the judicial power of the United States shall not be construed to extend to any suit in law or equity.
Say it again.
The judicial power of the United States shall not be construed to extend to any suit in law or equity.
And your point is?
Well, I just noticed that was in there.
Talking about
again? Pardon me?
And that's from where again?
The 11th Amendment to the Constitution of the United States. I think that's a statute a lot of people overlook. Amendment.
How many times have they said you can't bring that Constitution in their court?
That's true.
Did you ever ask yourself why?
I assume that we're not in the proper jurisdiction for it.
Yeah, that could be, but actually that Constitution is not yours. It's theirs. Everybody's got a big misconception about that. They swore an oath to that Constitution to uphold. That Constitution is not my Constitution, that's their Constitution. If we look up the definition of constitutor, what's the definition of constitutor? The one who took an oath to take care of paying the bills. Constitutor is where we get Constitution from. Constitutor, Black's Law 8th. A person who, by agreement, becomes responsible for the payment of another's debt. That's a fiduciary. That's a trust relationship. Okay, anybody else have a question? Press *6 and unmute.
Christian.
Yeah, Floyd, go ahead.
Yeah, I have a question about the protective order. Do we have, or can we get forms or what, some kind of an outline or something to show us how to do a protective order?
Yeah, I think Eric's got some forms and JT's got some forms that we've been working on. They really came out of the federal rules of evidence, or federal rules. The O'Connor's book has got some sample sample forms in there. And your local law library would also probably have maybe under Bender's or whatever they've got for a forms catalog or a forms book.
Okay. Now, when we put that in, do we put that in with the case, or how do we do that? How do we work that exactly?
Well, we're kind of up in the air on that. You know, if you don't mention anything that's truth, that's applying to your substantive rights or your so that they can be waived, then there's really, I don't think, any need to put a protective order on. But as soon as they start talking about some of these things, that's when you got to object and probably put a protective order on it, because now it's to protect it from getting out and waiving it. You have to make an objection and put the protective order on it.
So, in other words, if they want you to start mixing the public and the private together,
right. To get you to waive it.
Yeah. Okay. So then that's when you tell them that you can only reveal that in private or in chambers or some wording such as that.
Right. And there's some toss-up yet whether or not we want to put a protective order as soon as you go in, or we want to wait until somebody brings up something and then we want to protect it and clamp it down. Because that protective order, that's actually your manifested intent that you're trying to keep it private.
Yeah.
Can't be construed that you're trying to talk about it and make it public and waive it.
Okay, that's doing basically the same thing that the UCC1 and UCC3 is doing.
Yeah, give them notice. Yeah, it's an NOI.
Yeah, okay.
Protective order is an NOI.
Okay.
And it's a colorable motion or form that they can see that, you know, communicates with them what you're trying to establish or what you're trying to do.
Okay, yeah.
Another one?
Well, actually, I probably do, but at the moment, I'm kind of thinking about what we've been talking about here as far as equity and how it supersedes law and statutes and so forth. And
yeah, it's like we need to discuss, that what you're just talking about first and get that down, and then we can go into, what's the next step then?
Yeah, I think basically what we've learned so far is if we just go ahead and claim trust and go ahead and do the steps and understand why we're doing all of this, then it should pretty much just fall into place, because I think that the understanding the trust and going into trust or revealing trust or claiming trust really would take care of just about any of the situations that any of us could come up against.
Yeah, and trust is equity, period.
Right.
And that settles there is no adequate remedy at law, because we're not at law. We're in equity.
Well, you pointed out one time before that the fact that there is no money, trust has taken the place of money. So that automatically would tell us that our remedy is no money. Consequently, remedy has to be trust.
Mm-hmm. Force them to do the extinguishment of the debt, which is discharge.
Right.
That's House Joint Resolution 192.
Right.
So you get them to do 192 by coming under trust and a breach of trust and getting equity to force them to do the discharge.
Mm-hmm. I don't have a problem with that.
And what makes it hard is that nobody understands what they're standing on. And when they get challenged, they don't know what to say, and they fold.
Mm-hmm.
I don't see any trust here. I don't see any equitable claims. The judge is going to be asking you that. What are you going to tell him?
I think we just have to go back and when we go into court, put in our case as in the form of trust. That would then wouldn't you have that to refer to then? I mean, you have your
we're going to have to know that, hey, we're not claiming at law remedies. We're claiming equitable rights.
Right.
And it is a trust. Here's my evidence that it is a trust.
Right. We have our two public witnesses stating that in our UCC1 and our UCC3, and also in our public notices. So we have our witnesses there, and at that point, that is our evidence of trust.
Yeah, I would agree with that.
Okay.
Hey, Christian?
Yeah, Shane, go ahead.
Do you think, I'm going to sort of push my court and judges the gatekeeper theory again, and that they have all the control, and the best we can ever do is like kind of stalemate maybe. But do you think there might be something to, because I got Vic Beckles in the back of my mind, but I'm way behind on his emails. I wish I was up on them right now, because I do want to bring them to you. I think there's something that could cross-pollinate here. But do you think there is something to the idea of how we present the birth certificate as evidence of some kind of security, and with a proper presentation? Because I know that I've heard about this kind of thing with checks. If you present them properly to the banks in such a way they can't not
Well, everything's either going to be negotiable or non-negotiable. If it's non-negotiable, it's under equity, it's going to be in trust. Everything else is going to be at law. That would be checks, securities, all kinds of negotiable paper.
Okay, but if this was going to...
That's all debt.
This was,
that's all debt. And we don't want to do debt anymore because debt is negotiable. We want to stay on the private side, which is non-negotiable.
And if it's going to get resolved on the private side, with the judge or the court as acting as your fiduciary under the acceptance of the declaration, for example, if they did do it and resolve it, would they even necessarily tell you, other than to say that it's resolved, how they did it?
Well, I need to command them or order them to do what they're supposed to do and send me a receipt. And when they don't send me a receipt, they're in breach of fiduciary duty.
So, okay, so even if they did do it and they go into some back room or because I have seen people give them the birth certificate and they have come back and said, okay, that's been resolved. You're also saying that regardless public or private, there still should be some kind of a receipt as well, I guess.
Yeah, the fact that I've declared it is it's done deal already. Now, thank you very much. Give me one of those thank you receipts. I've got a document we dug up, and I gave it to some of the head trust ambassadors on a call the other night. But on page 3, it says here, quote out right out of it, says, this was in a document at a meeting of the President and Directors of the Bank of the United States on May 30th, 1794. It was talking about John Keene. He was the head cashier, and Phil Willing, who was president. And in this page 3, it says, under the form of power to transfer stock, it says, quote, the powers may be made general or special according to the will of the grantor. The powers may be made general or special according to the will of the grantor. That right there, that's the power. Didn't we just define power to be the ability to act or not act? Or in other words, make a decision towards whether you want to make a special deposit or a general deposit? And that's the will of the grantor?
Does that get back to expression of the trust, Christian?
Yeah, because talking about grantor.
Because you were saying way back that if we don't express it, they'll construe themselves, and they could construe themselves as grantor as well, right?
Yes, and they'll make your or misconstrue or construe your deposit to be general instead of special.
Right, all of it. Yeah, they'll just completely take it over. So, just to reverse logic that, if it's the will of the grantor, then we're almost going back to establishing yourself outside of their jurisdiction as the grantor.
Yeah, it's the will of the grantor that gets to decide. He's the one that's ordering, he's the one that's decreeing, he's the one that's commanding. And there is no question. They're the servants. And there was another one we read that was we found out that that's something to support that also. That corporations were nothing more than the servants of we the people.
Exactly, which is inequity. Equity to me sounds like customer service.
Yes.
But then some type, would it not be fair to say that some type of unequivocal way of communicating that we're the grantor would be in order?
Yes, order, or a declaration, or a decree, or a command.
I just meant in order in general, but yeah.
Non-declaratory language, yeah.
So, and again, you can't establish yourself as the grantor if you've already stepped into jurisdiction, or you're going to have a difficult time. And if you stepped into jurisdiction, then you miss stuff anyways, and you still got to back yourself out of it.
Well, you haven't claimed improved trust because that's why you're in the jurisdiction. If you would have claimed trust, you wouldn't be in their jurisdiction. You wouldn't be a defendant. You wouldn't be at the at-law side. You'd be in equity.
And so, like, I'd just like to point out that this is where the idea, the phrase I'm thinking of. Have you ever heard of that phrase? The game is won or lost in the first moves. So I think.
Yeah, I would say the game was won or lost before you even get to court. It comes down to whether or not you know who you are, and knowing who you are is knowing that you're a grantor. Non-secure party creditor.
I think like accepting the court date, showing up in court, recognizing the judge and all of them as such is all forms of jurisdiction.
If you walk into court and you got the claim and the pleading, and you got the evidence to prove that you are in a trust, and you don't listen to them, and you stand on the pleadings, you can't lose.
And you rebut any presumption of jurisdiction as well. You've got to identify those presumptions and rebut them.
I think that would rebut the presumptions, because now you've got evidence to support your claim, which is the NOI and the SOIs.
So I'm just trying to. I think there's different ways of looking at it. I think, in one sense, like an order of operations. Can they hear you? Well, if he says he can't hear you, you must have got pretty close to something. If he says I can't see you or something. But just maybe in a breaking it down type of fashion, whether that's correct or not, the idea that I used to say you've got to rebut it effectively, and then I forget what I used to say now. I got to go back to my own notes. But I'm just trying to think that I think if people are not being successful who have good paperwork is because somehow they stepped into it and then they're not even hearing what you're saying. Because, you know what I mean? Order of operations sometimes comes into these things, maybe. Is that possible?
Yeah, because they're always trying to get you to argue the facts and traverse into the case, and they've got jurisdiction over you. Instead of you sticking to your argument and getting them to argue it and rebut it and get them in your jurisdiction.
And I mean, their game is so devious is the fact that they're presuming that you showed up in their court is a form of jurisdiction.
Yeah, but then that's where we got to go. It's like we got to run the gauntlet to get into equity.
Yeah, and I'm just thinking it's the first thing that could come out of your mouth has got to be the whole jurisdiction thing before we start anything. Is it, is it one way or another? You're saying, is it clear before we even get started here that I'm not recognizing any kind of jurisdiction here? Let's get that out of the way, because I swear if you start playing on that, you'll see that. Well, in the criminal court, they actually followed it. Yeah. They did follow it.
Could I say something? What you just brought up, Christian, about running the gauntlet to get into equity. We've already run the gauntlet, haven't we, when we've determined that there is no money?
Yeah, but how are we going to prove that in court there? That's too truthful.
I think with our paperwork, with the NOI and the SOI, and bringing out the facts that.
Well, once you get those facts, then how are we going to get into court? And there's where we're running the gauntlet to get into equity. These guys are the gatekeepers. And until we get it figured out how we don't have to run the gauntlet, and I think that's next, and I think that is also doable.
Christian?
Yeah, I think somebody else is in line. I think Michael wanted to ask a question here.
Well, to get back to what we were talking about earlier, my question being is that with our initial cover page, we put private trust in equity, and then we put the information in that, meaning the Bible, Scripture as the law, and then also with the Declaration of Independence. And then we put the other information in regards to that with the UCC 1, 2, and 3, and also the county, and this will all go in camera directly to the judge, saying that this is a special private trust in equity, and we need in chambers because we cannot divulge this information in public to protect you in your position as trustee. Is that something how the language could go?
I think so, yeah.
Because, you know, from my experience, this is the only way that I can see. You might be able to win one or two, but you're going to end up coming across and getting a very defensive judge that would just get you for contempt of court and throw you in jail. I've already been in jail too many times, and I really don't like that area. So I think with doing this in camera, it is the best way to go in a protective way to keep you outside of their walls. With that, I'll sign out. Thank you for your time.
Okay, it was Jacob, you wanted to ask a question?
I got one.
Okay, go ahead.
Do you guys have something, just going back to the birth certificate again, because I think there's got to be something in that birth certificate. It's got to be simple for the simple folks if they have the understanding or modicum of understanding. We have that the birth certificate is for its purpose. It's not identification. They say that specifically, or somewhere. We've been told, I think, if Pete's on, I think he says if he reads on the back for us, that'd be very insightful. And but it is also states in our Vital Statistics Act that it's for the purpose for the use of evidence in the court of law, and then of course of its proof of the facts so certified. Like, I mean, how much more cryptic? That's got to be all that hidden talk and reference to the trust. I'm going to speculate at that point. And so I'm trying to get back to the presentation of that.
It was really a thank you receipt for your deposit that you made generally, and they gave you a receipt thanking you. And it was certification of your deposit.
So if you bring it in as evidence.
Representing the public side debt.
What kind of evidence would you use that in a court?
Well, when the mother deposited this, supposedly the child into general deposit, then they gave you the receipt, which was a certificate of deposit, the CD, which was a thank you receipt for your deposit. It represents the credit on the public side that is they're valuing it.
Could not that be used then as a colorful presentation of that evidence, and then that in turn is used as some kind of offset with the trust underlying that?
Yeah, that's why the NEAC seat has worked before, and when some people present that into court and as payment under the NEAC seat, that the surety went free.
And that was only colorful then, you're saying? Because really there was the trust.
Public side, yeah.
With the trust right underneath that, obviously.
Yeah, that got you a discharge.
Yeah, and it has been done. And yeah, I was thinking of the EXC tank, of course. See, so I don't know. I just think there's something there. And that is nice the way they like it, right? You just present that to them, and here's your evidence of the facts are certified. They take that, do whatever they're doing back there, right? Come back out. It is done. Always done. Because I mean that's the thing. We don't know what to do with those things. How to plug those in and do that processing.
Wait, you got a question? Well, on this paper I was talking about here, it's only 4 pages long. On page 4, this was under is at a meeting of the President and Directors of the Bank of the United States, April 22nd, 1794, it was resolved that any person claiming a certificate or certificates of bank stock to be issued in lieu of others lost or destroyed shall take upon oath or affirmation the circumstances of the loss or destruction, accompanying the same with such further and other testimony that they may be able to procure relative to the loss or destruction. The claimant shall advertise in one or more public newspapers for the space of 6 weeks an account of the loss or destruction, describing the certificate or certificates and its number, calling on all persons to show cause why a new certificate shall not issue to him or her in lieu of the lost or destroyed. And that the attestation or affirmations with the advertisement before mentioned shall be transmitted to the Bank of the United States, and the party shall give security to the Bank of the United States to indemnify them against any damages which may arise from by cause of the issuing of a new certificate or certificates in the sum of $500 for each share renewed, whereupon it shall be the duty of the cashier to issue a certificate or certificates of the same number and the tenure of the said to be lost, specifying that the same are issued in lieu thereof. Now, what's going on here? Forget the facts that they're talking about, say, certificates here. What is the model? This is a declaration. It's a declaration of the account of a loss or a destruction and how they're going to create it. They didn't go to a court or a probate court and ask permission to recreate some lost or destroyed certificate or permission to do something. What did they do? They did government. They acted like sovereigns. They acted like kings. They made a declaration, and they put in there a newspaper publicly declaring that anybody, all persons, should show cause why a new certificate shall not be issued to him or her in lieu of the lost or destroyed one. And when nobody answered, it stood good. That's what we need to be doing. If we want to break our guardian-ward relationship, we do it by making a declaration, and we do it some publicly known spot that we're going to be a show cause why this should not stand. And we're going to create the records that it's been done, and we're going to give the records to them that it's been done, and it's done. They knew how to do government back then. We lost that knowledge. That's how to get something resolved. We don't need to ask their permission. We get things resolved by telling them, but then we have to have the NOI and the SOIs to substantiate what we've already done. And we already had our hearing. Now, this was also notarized by a notary, and then it was said that 2 other notaries that certify that this notary is well known and duly qualified, given under their hand and seal. So there's your 3 notary panel for an adjudication. And all we want to do is, we're operating on the private side, doing our government on the private side in the Republic, and then we're noticing the public side of what's already been done.
Christian?
Yeah, Jacob.
Can you tell me where you just read all that from?
From a Rare Document Find website.
Oh, wow, I see.
You've already got it. We already gave it to you.
Okay. I have a kind of a, one of these puzzle questions. It has to do with a mortgage to start with, is the basis. when you are acting, or when you're the creator of the trust, and you've declared a trustee and a beneficiary, but you're making payments, and the trustee makes payments. Isn't that correct?
Yeah, he's supposed to be making payments, yeah.
Okay.
If it's debtor creditor, yeah.
No, I'm just talking about a typical somebody buying a home for themselves in their life. They go in there and they're grantor, but they turn around, they start making payments, and then there's a beneficiary, and they come to the realization that things aren't the way as they seem, and they express that it's a trust, and withdraw and declare a special deposit. Is there some kind of conversion that takes place at some point there where you're making payments and then you're not making payments? There's a change in the relationship, right?
Yeah, the nature of the deposits, yeah.
So if somebody decides to express that particular trust, and they're making payments, and they stop making payments, and they withdraw their general deposit, and they claim a special deposit and transfer back to the beneficiary, when they're making payments, well, even if they're not making payments, because they've got the deed of trust down at the county, they, like the main thing, it seems to me, is like the question you always say, like, how are you holding your estate? Yep. Even though they're doing all that, they're still holding their estate as a legal title holder. How does it change? During that whole process, is that when they've made the bank the trustee, and the bank is the beneficiary, and they've transferred the trust property and have their trust receipt, and the beneficiary is now holding that special deposit, is there a transformation or a conversion of that person? And if they were to take themselves out of the county, would there be a transition that they are no longer holding their estate in legal title, and they are actually the beneficiary waiting for equity to make that known?
Yeah, but when did they do all that?
Well, it's over a period of time. It's going to be different for every story, I'm sure. I guess they're holding their state legal title.
When did they do it? They didn't do it yet. Nobody's done that, right?
Well, I'm trying to figure out when you go in to stand before the judge to get into equity, and you're the legal title holder, and you're not the beneficial title holder, but you've transferred the trust res and made the payment. They just haven't, and you've got a breach of trust action going there. When all is said and done, you're not going to be the legal title holder. Isn't that right? Did I get cut off?
Oh, I'm here. I'm sitting here talking, and I forgot the mute button on.
Oh, God. I guess my question was, that question is the most beautiful question you can ask someone. How do you hold your, how do you hold your estate? And if they're holding it in legal title, but they decide that they are going to express and they're going to make a withdrawal and a transfers of a special deposit, and they're going to, when you order to have the obligation extinguished with the beneficiary, at that point, do you become a beneficiary? So that when you stand in front of the judge to go into equity, you're standing in a different. Your estate is not being held in legal title when you're before the judge.
Yeah, your status. If you change your status
now beneficiary as opposed to trustee or misconstrued trustee. Yeah, you're kind of like grantor. You're like grantor trustee, and you're converting yourself to grantor remainder beneficiary.
Yeah, whichever way you want to put it, because if it's trust, it doesn't make any difference probably if you're trustee or beneficiary. It's out of the jurisdiction. You switch generally to equity, to a special deposit.
Yeah, but are you holding your title in legal title or beneficial title at that point after you've made the payment?
Well, it depends on what side of the trust you're on, whether you're trustee or beneficiary.
Well, you were grantor making payments and acting like a trustee, and I'm not even talking about a foreclosure.
Yeah, that's colorable. That's colorable terms, making payments, which is a misnomer, really. How can you make payments at all? It's all colorable.
No, but there's 65 million Americans that have homes. Maybe 5 million are in trouble, but there's 60 million out there that are underwater, and they're holding legal title.
Well, I hope that is the rock in the hard spot, but God put them in the wine press, trying to make them wake up to the fact that they're holding all their assets generally under a general deposit, and they need to change that from the nature of that deposit from general to special, and switch it from at law, debtor creditor, to equity, where you got substantive rights. And then it has nothing to do with the value of anything, because it's got to do with thing or res. Substantive rights. That has no value.
And when they do that, is there a conversion from legal to beneficial title holder?
Yes, it's called merging titles.
And when you merge the titles, when they merge the titles, they are now transformed from legal title holder of their estate into beneficial title holder.
Yeah, welcome to NTT.
Yeah.
You're pulling yourself out of the jurisdiction and being the defendant at the at-law side and the general deposit, and you're moving it over to the equity side where you made a special deposit under trust. Except now you got to prove that there was a trust upon your claim that there is a trust, and then execute the trust.
Okay, here is I think this is like probably 1700s, okay? And this is equitable estate and interest. And the question is, what is an equitable or beneficial interest? And it says, unlike leasehold and life estates, equitable interests are not carved out of the legal estate.
That's a right.
A right.
It's a right. That's all it is. That's equity.
Rather equitable interests are either impressed upon, annexed, or ancillary to legal estate. The terms equitable interest and beneficial interest are often used interchangeably, although strictly they are not synonyms. A beneficial interest, which has been described as a term of infinite variety rather than fixed import, is probably best thought of as being wider in meaning than the former. And it says, equitable interest exists only when the legal estate holder does not own the property absolutely. That is, when the owner of the legal owner does not enjoy full beneficial ownership of the property.
Yeah, the trustee's got legal title. That's at law. Beneficial interest in the beneficiary, that's equity. There's your two sides.
When we have a breach of trust as a cause of action, and we're going into court regarding receiving equitable treatment, then if we come in there, if an entity comes in there, a man comes in there, and he's holding legal title, then is he going to be disallowed to get into equity?
Equity can't see legal title. Equity's only going to address beneficial rights. And that's the ultimate owner, the legal title. Because the Court of Equity is going to look at that beneficiary as having already being the owner of that legal title. Because the trust is a duty to him to give him, according to whatever the indenture was, that right.
When you make a pleading with a cause of action for your motions and you put those forth into the court, we're going to enter in the NOIs and the SOIs in those pleadings?
No, the NOI is just going to be in the pleading.
Just the NOI?
The evidence of the SOIs is going to be in chambers.
Okay. So is it going to be the SOI that declares that we're beneficial title holder and we're no longer legal title holder?
Yeah, that's the proof of the trust, is your beneficiary.
So that's where the transition takes place then?
Yeah, that's what we're trying to bring out. That's what we're trying to flesh out tonight.
Okay. Just trying to... Okay, well, thank you very much.
How to get a remedy in equity. How to get into equity so we can get a remedy. That's what the call is about tonight.
When we have that SOI, we've transcended from a legal title holder to a beneficial title holder, and we're entitled to justice and fairness to have the judge compel the trustee to make it, to do his fiduciary duty and extinguish that obligation that's standing in the way of the transition?
Yeah, equity is going to enforce the conscience of the court, and we're going to apply to the conscience of the court for equity to be done.
And the judge is going to be the enforcement to have the trustee do that?
No, equity will be.
But the judge has to order it?
Yes, yeah. Equity considers to be done which should have been done.
Okay, I'm trying to understand that. It really helps a lot seeing, because realizing that at some point there's like the change from the way we're holding our state is changed from legal title holding to beneficial title holding.
Well, if everybody go get corpus juris secundum and look under the Book of Equity, wherever book copyright they got, and just copy the section of equity. It's about 250 pages long. and just start reading it. They're going to see a whole different realm. That's where your remedy's at in equity. But yet nobody knows anything about equity. I don't know anybody talking about equity. Only Jack Smith for a while there is talking about substantive rights and equity. But that's as far as anybody ever goes. Just like the trust thing. Everybody says it's all about trust. But nobody goes down the trust law route. Nobody goes down the trust rabbit hole. We all go back down like a dog to its vomit, back to the debtor-creditor, UCC, negotiable instruments, and we go right back down that rat hole. And then we wonder why we don't have a remedy. And then if we do get a remedy under that realm, that law, that's not the true remedy. You still lost, even if you won. You can't get a remedy at law. What this stuff is saying, there is no adequate remedy at law. There is no money. That's the ultimate issue. Even if you won and got your house back, where do you think the value of your house is if there is no money? What did you really? You got nothing. Zero. De nada. It has no value. What did you get?
Hi, Christian.
Did it solve your problem? Go ahead.
Did you just say it states that there is no remedy at law in there?
Yes, that's what we're talking about. There is no remedy at law, period.
And didn't you earlier state when something to the effect about when it's finally gotten to the stage where all the opportunities to try and find remedy are exhausted, that that's when they can move into equity, or something to that effect?
Yeah, because they were saying that you're supposed to exhaust your administrative remedy or exhaust your remedies first at law, and then you can apply to, say, equity and get in there, because now there's no adequate remedy at law. Well, I got news for you. In everything you do, there is no adequate remedy at law, period.
So, and is that stated like...
At law, you got to be paid money for damages. If there is no money of any value, how can you be compensated and get a remedy? Can't. Can't. Therefore, there exists absolutely no remedy at law, period. Why are we going down the at law side? Arguing the stupid fiction law. We should be in trust and equity. The only place we can win.
Christian.
Yeah, Floyd.
You said I think we've determined that the NOI is the UCC1, the SOI is the UCC3.
Yeah. Yeah.
Okay. All right. Well, I just wanted that clarified because that's just another affirmation of that we need to be doing trust, period.
And then I would put similar to the UCC1, making a claim on, say, the petition or the pleading as a cause of action. And then I'd be substantiating again with the SOIs, but the SOIs is in chambers.
Okay.
But the more we talk about this stuff, equity, I don't see anybody taking it down any farther than just mentioning it. All they're doing is just making a claim. They're just making an SOI. And they're not following it up with any facts, any SOIs to support the claim, which is the NOIs. Well, it's all about trust. Yeah? Where's the facts? It's all about equity. Yeah? Where's the facts? Everybody who makes a claim has got to substantiate the claim, or else there is no claim. He who makes a claim for trust got to prove trust. Maximum equity. Anybody who makes a claim, period, has to prove the claim. Maximum equity. Equity's got everything to do with rights. Like Bill was talking about. The outlaw side is about privileges. Anybody else? Question? Anybody else?
Hello.
Yeah, Pete, go ahead.
Yeah, I'm just looking through the books, and it's talking about, like, in secret trusts, you know, a trust can be done by conduct.
Uh-huh.
So, wouldn't that, you know, demonstrate something about substance?
Yeah, I think that's probably a private trust. And that's a secret trust.
Yeah. I was just reading a little bit earlier again. It was saying, you know, you might not realise it, but you're entering into trusts in all sorts of different ways.
Yeah, like way back when we first started all this, we were talking about Gilbert's and the law restatements, second on law and trust. It was saying that no one in a trust needs to know that a trust is being formed.
Yeah.
Which sounds like an impossibility, but no. As long as the law will recognize what has been done, if the necessary elements and the method of formation is there, that the law will recognize it's a trust.
Yeah, there it is. Declaration by conduct. An effective declaration of trust may also be inferred from conduct, even though no words approximating to such a declaration are used. In Vandervelde's trust, the Vandervelde Trust Company held a share option on trust for Mr. Vandervelde. The option was exercised using £5,000 that the trust company held on separate trusts for Vandervelde's children. Thereafter, the trustees wrote to the Inland Revenue, which is the tax, saying that the shares would be held on trust for the children's settlement, and dividends arising from the shares were henceforth paid into the children's settlement. Given that this was all done with the full assent of Mr. Vandervelde, the Court of Appeal held that the evidence of the intention to declare a trust was clear and manifest, and that the trustee company held the shares on trust for the children.
Uh-huh. And nobody knew it was a trust.
Yeah.
No trust terms were mentioned, although everything was there to substantiate a trust, and it was a trust.
Yeah. Then it goes on to talk about constituting the trust by transfer. It even brings in, like, copyrights, chattels, bills of exchange, and equitable interests. If the intended trust property is an equitable interest enjoyed in property by the settlor, it can only be transferred to the trustee by writing as required by law. And yeah, it's just contradicted itself, saying that it can be, you know, declared by conduct.
Mm-hmm.
But I understand what you're saying about where you're given notice, so that the facts, aren't they, that you've established that the trust relationship's going ahead, which is what the declaration by conduct is saying, is that, you know, it's in written evidence. But what I don't understand is how equity will see a private trust when everything at law has to be in written form. Why would it need to be in written form in equity as such? Simply because people may not have the not capacity, but so, like, it may be someone who's foreign to the land and they don't have any means to write it in English, or, you know, there are various ways that it could be by way of conduct alone.
Yeah, there was, Gilbert was talking about that if the grantor was also the trustee within himself, well, the appropriate method for making a trust formation was by declaration, because how else would someone know that the grantor had transferred property to the trustee when the grantor was also the trustee? They would only know that by declaration. So it had to be a manifested intent by a record to prove by declaration that a transfer had taken place. So on the public side, they always have to have some kind of manifested record to prove that there was a trust. But on the private side, there could be just a confidence agreement, which could be oral between parties.
Yeah. And in the case of a public trust, that's a,
yeah.
You know,
yeah, but in order for us to get into equity, now we got to go through the public side to get back into the private side, which is in equity in the chambers.
Got ya. Yeah.
So these public entities are acting as the gatekeepers by legal fictions that are protecting the ancient treasures, which are your substantive rights, which is the definition of Black's Law of legal fiction, which I keep reading.
Yep.
So it's kind of like running the gauntlet, because these guys are the gatekeepers. And we got to put the face mask of the straw man on with enough to know, which is the aged majority, that we don't traverse into the case and grant them jurisdiction by doing that. We come in and we command them that the jurisdiction is equity. By having the amount, on the pleading, the NOI, which is the cause of action, and the evidence, the SOI, which is going to be put in chambers. And we don't argue jurisdiction.
Now I'm thinking that in the court, the judge is going to fight tooth and nail to keep you out of equity. You know, he's going to use every trick in the book to keep you in the at-law side. So you basically got to stand with what you're saying. You've brought your facts.
If we
And
tie
even,
in,
you have said
tie-
it before, even if...
Did you get that 4-page? Did you get the download from the other night?
Yeah. Yep.
Got that? I think that show cause hearing is a good example of how to make a declaration that stands.
Show cause hearing.
Yeah. It might be so simple as do a show cause hearing why the trustee should not be held in contempt for breach of trust, because he didn't do a disbursement of the funds.
Well, it does seem like everything is laid out simply, and we just have to get the terminology right. You know, to make it look simple and to be simple. So all this study is warranted, like.
Yeah, it's sifting through all this wheat to get to get rid of the chaff.
Yep. So that Coca-Cola one still interests me, you know, where they've gone in under the trade secret.
You dug that up?
No, I've been looking, but nothing's come to light.
I'm sure there's probably others like it. I don't know.
Well, there must be, because there must be a lot of trade disputes between companies who, you know, say they're my ingredients, and another one says that's my ingredients. I know I've been approached by some music guys, and they've been asking me about how to kick out the, the corporate people who are making all the money on the back of the artists' work.
Well, we got to get out of this thinking that this public debt's money. It's debt. It's getting farther and farther, and it's mounting up into more and more debt, and we think that's money. Boy, we've been conned in a confidence game. We're being duped into trusting that that is money. We got to get them for a breach of trust.
So are you talking about taking US to court and getting them on a breach of trust?
Possibly you could do that, yeah. Well, what's the definition of credit in Black's Law?
Trust.
Trust, yeah. Trust is credit, credit is trust. Really amazing. It's like you start taking these trust rabbit holes, and no matter which one you go down, you come back up on the same place. Come right back to trust again.
Yeah, you can't really go anywhere, can you? Because you're in substance.
Yeah. We have to get out of this mentality of things have to have value. No, everything is valueless. It's all prepaid. We just need to use our labor as creating things, as grantors, and then gifting them to somebody as beneficiary, and demonstrating our love rather than it's givers versus takers. Debt is a system of taking. Trust is a system of giving.
Yep.
And we all have the power to use the force.
Yep.
The power being the discernment to make the choice to act or not act, to make a general or a special deposit. And if we goofed up and we made a general deposit, we can always withdraw it and redeposit it and correct the mistake. Merge the titles, extinguish the debt. And if they don't want to do it, we go into equity, and equity is our force.
So, could you just describe to me how is a contract in equity?
Well, that would be a private contract, I suppose, on the private side, between two parties. And each one would have to be sent here in agreement and under full disclosure of knowing the terms of the agreement before they assented to the contract.
So then the bill in equity would come off the back of that then, I guess.
Yeah, if they breach the contract, then you could come under a bill in equity for enforcement of the breach of a private contract.
Okay, brilliant. Thanks a lot, Christian.
All right. Anybody else? Star 6, anybody? Nobody else? All right, let's call it a night then. All right, I thank everybody for coming tonight and putting up with our mistakes. It's been a hectic night, so bear with us till we get the bugs worked out. So I'd like to say good night, everyone. See you tomorrow night.